process for First Nations economic development is missing. William J. Wolfe composed a list of the main impact benefit agreements signed during the first 10 years of them through the 1990s. He said each of these is the product of a unique negotiation. No two are exactly alike. He delivered a report to the Prospectors and Developers Association of Canada after observing the 10-year history of IBAs. Wolfe writes, "These agreements often contain so-called soft language and depart significantly from the style and format of the precise legal contracts to which the corporate culture is accustomed." And he continued, "In fact, one might reasonably ask, what are these agreements? Are they statements of good intentions? Are they memoranda of understanding? Are they enforceable legal contracts with penalties for non-performance and procedures for dispute settlement?" While no doubt the same questions remain in 2008, IBAs that are initially forced by First Nations provide a security blanket to corporate Canada, said Sanderson, who called IBAs acts of de facto governance and said IBAs are helping First Nations to expand jurisdiction. In fact, he said governance aspects are the most important part of IBAs. According to Wolfe, the main expectations of First Nations signatories to IBAs begin with recognition of Aboriginal rights and sovereignty. Then other priorities include employment, percentage targets and hiring policy, and training scholarships, and access to other governance functions, including investment. For corporate Canada, as regards the mining sector at least, said Wolfe, IBAs must provide several things: clarification of resource ownership and taxation powers, assurance that exploration investment is linked to an exclusive right to develop, mine, and market mineral products, and the usual allowances, accesses, and conveyances accorded commercial activity. Wolfe wrote, "Most of these requirements are well understood by political jurisdictions that aspire to attract mineral exploration and investment. They are by no means uniformly obvious to newly constructed Aboriginal political institutions. Certainty has occurred in some jurisdictions through IBA signings, but it is by no means universal, and IBAs are non-binding. In fact, the greater boondoggle to investment with First Nations happens to be the lack of legal recourse. Neither party perceives a functional outlet in searching for resolutions to difficulties. First Nation leaders in Kitchinamekusa and Nunavik who are imprisoned for blocking access to Blacknex mines represent a primary example, the very political economic dichotomy that exists over jurisdiction, which cannot by appearances be resolved in the existing courts." Sanderson said U.S. tribal communities have their own courts. And at the University of Toronto, said Sanderson, examination is underway about the need for a commercial code of law for First Nations based on the U.S. model. Corporations such as resource companies would be encouraged to register as business entities on such reservations as host the court, and then encouraged to choose the venue as their choice of laws for dispute resolution, having thus registered their businesses on reserve and submitted themselves to this legal framework. This is a way, he said, of extending First Nations jurisdiction over commercial activities. In the pursuit of providing certainty, this is another venue that would allow it, said Sanderson. Commercial courts for Indian reserves.